So in this video, I have an update for you in the Texas Suppressor Freedom case, which aims to stop the NFA and ATF's regulation of suppressors. So let's talk about what is happening. Now, real quick before we jump into this video, I want to thank one of the main supporters of this channel, which is 1st Phorm. 1st Phorm is an amazing company. A lot of you guys know that I've been using them to help me along with my fitness journey. And not only are they an amazing supplement company, but they share a lot of the same values that we do here on the channel. They believe in freedom, they are pro-American, and they are also pro-Second Amendment. Check them out using the links down below. And if you're signing up for the first time, you can get a 30-day free trial of their new fitness app. So again, check them out, and thank you again to 1st Phorm for sponsoring and supporting this content. As I mentioned in the intro, in this video, we're going to be discussing the Texas Suppressor Freedom lawsuit, which aims to eliminate the NFA and ATF's regulation of made in Texas suppressors. The ATF is now trying to get this case thrown out of the 5th Circuit by arguing that any positive decision will cause an improper circumvention of people paying a required NFA tax. The case we're going to be discussing and breaking down is called Paxton v. Dettelbach. And now all this is coming to a head with oral arguments which have now been set and will take place in front of the 5th Circuit on May 1st. That means that the 5th Circuit Court of Appeals will now decide whether or not this Texas Suppressor Freedom case should proceed forward, or whether or not it was properly thrown out by the lower court, and whether or not this whole dispute about made in Texas suppressors will proceed forward, and whether or not the ATF will lose this ability. The ATF recently submitted briefs to the 5th Circuit saying that the 5th Circuit should uphold the lower court's dismissal, and they even argued that the 5th Circuit did not even need to hear oral arguments in this case. However, the 5th Circuit rejected that argument by the ATF, and they will in fact hear arguments in this case. In their brief, the ATF once again argues that as accessories, suppressors are not bearable arms protected by the Second Amendment. The ATF also argues that the required NFA tax makes this lawsuit invalid. But the plaintiffs in this lawsuit, Texas and the individual plaintiffs, exposed those ATF arguments, pointing out that this tax issue is 100% irrelevant, and really, it's irrelevant for this case proceeding forward in the 5th Circuit. Now, for those not aware, this lawsuit arises out of Texas House Bill 957. HB 957 aimed to exempt from federal regulation all suppressors that are made in and remain within the state of Texas. The claim behind this law is that since these items are made and sold exclusively within the state, they do not fall under interstate commerce, and therefore they fall outside the purview of federal regulation by the ATF. After Texas passed that law, the ATF did send out letters to a bunch of FFLs and individuals saying that they will still in fact enforce the NFA and GCA's regulations against made in Texas suppressors. So again, this is a case that's still being litigated. This is an issue that is highly debated. The ATF is still enforcing the NFA laws against made in Texas suppressors. So again, wait for this to develop. Wait for the case to resolve before you engage in any of this conduct, just a point of warning. Now, in response to this position by the ATF, Texas, along with individual plaintiffs, then filed a lawsuit in federal court against the government and the ATF. This case was then submitted to a federal district court on cross motions for summary judgment. Well, after reviewing the case, the district court granted the motion in favor of the government, the United States government and the ATF. The court ruled in favor of the ATF under the rationale that the plaintiffs lack standing to bring this lawsuit. Now, on review, the lower court judge found that the plaintiffs have not suffered an injury in fact, and therefore they have no standing to bring this lawsuit. So they threw the case out because they believed there was a lack of standing and a lack of injury. Here, the judge essentially stated that the individual plaintiffs would have to allege that they possessed an illegal silencer or that they engaged in some sort of prohibited conduct that the ATF claims is illegal. The court here also said that maybe one of the ways to cure the injury was for the plaintiffs to actually go through the process to try to register these made in Texas suppressors, either get approved by the ATF or get denied. And the court said then maybe that could be something where you can prove that the process itself was an injury, but you would have to subject yourself to the process in which they are actually challenging. The judge also stated in his opinion that alleging the law is unconstitutional and impacts Second Amendment rights is not enough to remove the burden of establishing standing and showing some sort of injury. In response, Texas then appealed and asked for the 5th Circuit Court of Appeals to review and ultimately reverse that lower court decision. The ATF responded to this appeal and argued that the 5th Circuit should essentially affirm what the lower court said, dismiss this case, and also find that there is no standing to bring this lawsuit. The ATF argued that under the Tax Anti-Injunction Act, or the AIA, this lawsuit was improper since it would result in the avoidance of paying a required tax under the NFA. The ATF claims that the AIA prevents something like this from happening and also prevents this type of lawsuit from taking place. Then the ATF argued that the Second Amendment is not implicated at all when it comes to suppressors. The ATF stated in this brief that the Second Amendment's protection extends only to instruments that constitute bearable arms and that are typically possessed by law-abiding citizens for lawful purposes. Because the Second Amendment covers only bearable arms, laws that regulate firearms accessories or attachments do not necessarily implicate its protections. And a silencer, according to the ATF, is a firearm accessory. It's not a weapon in itself. The ATF's two main arguments in this case for why the Fifth Circuit should affirm what the lower court said and throw this case out is first, that ultimately if the Fifth Circuit rules in favor of us in the state of Texas, the NFA's tax requirement, which implicates the AIA, would be circumvented and that would cause a significant issue. And then they also double down on their position that suppressors are just accessories and therefore they fall outside the protection of the Second Amendment. That, of course, directly runs contrary to what the ATF has said in language in the NFA and GCA talking about how suppressors are actually firearms and regulated as actual firearms, but they just want the court here, the lower courts, the Fifth Circuit Court of Appeals to just ignore that. Now, in response to these absurd arguments, the plaintiffs just kind of completely obliterate them. First, Texas points out that the tax issue is not even at issue here on appeal. Texas argues that that issue is not before this court. The parties extensively briefed this issue below, but ultimately what the lower court did is they found a lack of standing, but they did not include any discussion on the Anti-Tax Injunction Act or this whole NFA tax circumvention issue. The plaintiffs say that instead it decided only standing and only the injury in fact prong. The court should not consider the parties' Anti-Injunction Act arguments. The district court should consider them on remand. What Texas points out here is this appeal is all about standing. The lower court dismissed the case because it believed the plaintiffs and Texas lacked standing to bring this lawsuit against the ATF. The main basis for that was the court said that there was no injury in fact to meet the standing requirement. The court did not consider the whole NFA tax issue, the implications of the AIA, and any determination like that needs to be considered on remand, but does not need to be addressed by the Fifth Circuit Court of Appeals. Texas then pointed out because the Supreme Court's recent 6-3 decision in Bruen, which struck down New York's concealed carry processing scheme, Texas and the plaintiffs here actually do have true standing, especially under Bruen, to challenge this NFA process. Bruen was all about challenging a permitting scheme and a processing scheme to exercise your Second Amendment rights, and that's also what's at play here with having to apply through the NFA process to take possession of a suppressor. Texas argues that post-Bruen, whether citizens may challenge requirements to apply for permission to exercise Second Amendment rights is an open question. Although the ATF cites these opinions as controlling authority from this court, it saves this argument for last, surely because it recognizes the shaky status of these opinions post-Bruen. Here, Texas is directly using the Bruen decision to point out that post-Bruen, they now have the ability to challenge the application process and these types of NFA processes that use and serve as a barrier to exercising Second Amendment rights. That is exactly what is challenged in this case, and therefore the lower court dismissing this case for a lack of standing also directly violates what the Supreme Court said in Bruen. As I mentioned, the ATF wanted the Fifth Circuit to agree with the lower court's dismissal, and they even argued that the Fifth Circuit did not need to hold oral arguments in this case. They could simply decide it on the briefs and kick this case. But the Fifth Circuit has rejected that position. The Fifth Circuit has now set oral arguments, which will happen in this case, and the hearing is currently set to take place on Wednesday, May 1st at 9:30 in the New Orleans Federal Courtroom, which is, is one of the areas where the Fifth Circuit sits and hears these cases. This is going in front of a 3-judge panel, and they will determine whether or not this case should have proceeded forward in the lower court and whether or not the lower court was incorrect in throwing this case out based on a lack of standing. I'm excited to hear the arguments in this case because, really the absurd NFA tax position that the ATF is making, it's going to be interesting to see if that pops up during these arguments because that's one of the ATF's main positions. It's going to be interesting to see how they address that and how the 3-judge panel addresses and kind of grapples with this. I don't think we currently have the judges' makeup for the 3-judge panel. When I get that information, I will let you guys know. And then also when the hearing is set, you can listen to it and sometimes even watch it live. So I will find a link and leave that down below so you guys can listen as well. So definitely an important case, an important appeal going forward. I know a lot of people in Texas are very, interested in the outcome of this case. But again, I want to warn everybody, understand that the ATF is still applying the NFA's process against Made in Texas suppressors. So wait for this case to play out. But again, if we get any more information, if anything else develops, I will let you guys know. So if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. But as always, thank you all for watching. Don't forget to like and subscribe, and never forget, this nation was built by ARM scholars, and this nation will be maintained by ARM scholars.